A casino license is not just permission to run a business. It is a public privilege, and that depends on trust.
So what happens when a casino keeps operating through serious legal doubts, and the lawyers in the room respond by preparing arguments for later instead of saying stop?
That is the question at the center of the Crown Melbourne Royal Commission, a story involving disguised money transfers, unpaid tax, frustrated investigations, and legal advice that continuously treated compliance as calculation.
Today we are looking beyond what the Crown did. We are asking what the lawyers noticed, how they judged the problem, and what pushed them towards the wrong decision, and what would make a different outcome more likely next time.
First, we need to know more about the case. Crown Casino Limited was first granted a casino license in the state of Victoria on 19th November 1993 by the VCCA, following its probity investigations of the Hudson Conway Consortium. It is also worth noting the Victorian regulations surrounding casino licenses, the Casino Control Act and the Casino Management Agreement Act. We're going to call them the CCA and CMAA for convenience.
The important point is that suitability was not a one-off test in 1993. Crown had to remain suitable for the life of the license. That meant maintaining good character, honesty and integrity, and meeting 6 norms of conduct that casino operators must conform to. Obey the law, act honestly, deter illegal and immoral behavior, not exploit people who gamble, take active measures to minimize gambling harm, and cooperate fully and candidly with the regulator and government.
This is important as Crown was therefore not an ordinary commercial client. It held a state-granted privilege and was described during the commission as needing to be super perfect. Its lawyers were advising inside that elevated setting. You'll see how this ties in later.
There are 3 strands of conduct that are essential to our analysis. The first is the China UnionPay or CUP process. Between 2012 and 2016, wealthy Chinese patrons had used CUP cards through the Crown Towers. The hotel issued room charge bills, even though no hotel service had actually been supplied. The patrons received a voucher and exchanged it at the casino cage for cash or chips.
The purpose was to work around China's currency export limit of $50,000 a year. Individual transactions could reach $500,000 a year, and the process enabled transfers of up to $160 million.
The legal team was involved from the beginning. In August 2012, Michelle Fielding, the Group General Manager for Compliance, and Deborah Tigoni, the Executive General Manager for Legal and Regulatory Services, were asked whether CUP could be used for the transfer of funds for international patrons in order to gamble. Fielding identified relevant provisions, but focused on how the Crown could argue in reply if the regulator disagreed, rather than clearly advising whether to proceed. The warnings became harder to miss. A bank officer said CUP cards could not be used to cash out, place bets, or buy chips. Tigoni's response was that a transaction was not valid if it were illegal. By 2014, the Commission and key staff were obviously worried, yet CUP continued, and the Crown later discussed extending it to Perth.
The second strand was casino tax. From 2011, Crown treated promotional costs, including food programs, gaming credits, and rewards, as deductions from gross gaming revenue. That reduced the casino tax it paid. Crown's own internal and external legal advice said that those items were not, or were probably not, deductible. Tigoni's 2012 bonus jackpots memo acknowledged the doubts, but assessed detection as unlikely and said the Crown could make a reasonable argument if needed. By the time the issue was exposed, Crown had repaid more than $61.5 million in tax and interest.
The third strand was the response to regulators. In 2016, employees of the Crown based in Guangzhou were arrested for the contravention of marketing laws regarding gambling in China. Following these arrests, the Victorian regulator requested board minutes, risk material, and communications. Fielding did not respond to the request, despite follow-ups. Later, Crown's tax response used neutral technical language without revealing that its own advice had questioned the deductions.
The Royal Commission's conclusion was blunt. Strategies were adopted to thwart and frustrate regulatory investigations, and lawyers were often involved as designers or at the least willing accomplices. After the Bergen inquiry found Crown Sydney unsuitable, the Victorian Finkelstein Royal Commission also found Crown Melbourne unsuitable and non-compliant. A special manager was appointed for 2 years to oversee reform.
But our focus is narrower. How did trained, senior lawyers see so many warning signs and still fail to change the direction of the client?
To assess lawyers' ethical decision-making, we are using psychologist James Rest's four-component model. The model says ethical action depends on 4 separate elements working together.
First, the moral sensitivity. Do you recognize the ethical issue? Second, judgment. Can you identify the right action? Third, motivation. Do the ethical values outrank the profit and pressure? Fourth, character. Can you actually follow through? A person can succeed at any one stage but fail at the next, and that distinction is crucial here because Crown's lawyers were not simply unaware of the facts.
Let's start with sensitivity. Did they even know there was an ethical problem? The lawyers clearly noticed legal risk. Fielding identified relevant provisions, while Tigoni recorded concerns about illegality and doubtful tax deductions. Their own language used in internal file notes reviewed in the Royal Commission showed anxiety about CUP and anti-money laundering exposure.
The legal risk and ethical awareness are not identical. The question should have been, should our client do this? Instead, it became, what can we say if the regulator finds out? That reframing caused ethical fading. The moral issue disappeared behind the language of exposure. Crown also lacked a reliable process to turn warnings into action. In the Burgeon inquiry, the Commissioner discussed how an executive flagged the unregistered Guangzhou office, but the concern was ignored by the in-house counsels and other executives.
Next is judgment. Tigoni recognized that the tax deductions were probably unavailable, but recommended proceeding because detection seemed unlikely and an argument could be built later. The same pattern appeared in Fielding's CUP advice, not a clear direction to stop, but a plan to argue in reply if challenged. The Commission compared Crown's approach to Oliver Wendell Holmes's bad man view of law, treating a legal rule like a price, discounted by the chance of enforcement.
Then there's motivation. Let's say you noticed an ethical issue and you know the right answer. Do you care enough to act when your employee's profits are sitting on the other side of the scale?
This was not only an individual choice. Crown's profit-driven culture rewarded advice that kept operations moving. Sociologist Diane Vaughan called this normalization of deviance from her work on the Challenger disaster. An organization that allows repeated departures from the proper standard permeates the organization's new standard.
Now zoom right out, because this part is bigger than Crown. There's a long-running theory of the lawyer's role called the standard conception. Scholars like William Simon and David Luban break it into 3 key parts, but the gist is that a lawyer serves a client's legal interests and leaves the morality to someone else.
Finally, character. Fielding, Tigoni, and Preston shared common attributes. They were all senior and well experienced. These experienced lawyers could draft firm advice, escalate concerns, and insist on disclosure. The failure was not technical skill, but sustained lack of courage and perseverance against a powerful, high-paying employer or client.
However, there is one qualified exception. Joshua Preston refused when document destruction was allegedly suggested. The allegation was denied and unresolved, and he did not take the underlying issue to the regulator. Despite momentarily displaying good character, Preston's judgment was still clouded by other ethical influences at play.
So the failure crossed all 4 components. Warning signs became technical risk, judgment was driven by the probability of penalties, commercial interests displaced ethical motivation, and the lawyers did not follow through.
Here's the uncomfortable part. These weren't people without legal training, seniority, or a warning. They had all 3. So maybe the most useful question isn't, how could they miss it? Maybe it is, what happens when an entire workplace teaches smart people to see the wrong choice as the practical one? And that takes us from the decision inside one lawyer's mind to the forces around him.
In legal ethics, we've got a name for those forces. An enabler makes ethical action easier, whereas a disabler makes it harder. At Crown, disablers operated at 3 key levels: individual, organizational, and professional. With Crown, we'll explore these through the lawyers themselves, the company, and the profession.
At the individual level, the strongest disabler was rationalization. The lawyers did not say, "We are helping unlawful conduct." They converted the issue into a more comfortable story. The risk is low, the position is arguable, and we can defend it if necessary.
Behavioral ethics researchers call this loss framing. Stopping meant a certain immediate cost, an angry client, and lost revenue. Getting caught felt distant and unlikely, so the brain quietly picks the comfortable option, then dresses it up as legal advice.
But nobody rationalizes in a vacuum, and this is the level that matters the most: the company. Crown's culture did half the work for them. The Commission found profit came first at Crown, at any cost. Advice that kept the money flowing got rewarded. Advice that shut things down did not.
Time then reinforced the culture. Tagoni was effectively allowed to treat conduct as acceptable because Crown had been doing it for ages. That is normalization of deviance in action. The history of the practice became a substitute for its legality.
On top of that, no safety net. Crown lacked safeguards that could interrupt the pattern: routine compliance audits, independent review of standing advice, and a clear process for escalating and resolving concerns. The unlicensed Guangzhou office showed that a warning could simply be ignored.
External review also failed. Alan Linklaters received bonus jackpot documents whilst preparing breach schedules, but the issue was omitted. The Commission called the omission inadvertent, but the result was continued non-disclosure.
Now, at the professional level, a narrow version of the standard conception became a disabler. Simon and Lubin describe a model in which the lawyer pursues the client's lawful interests and leaves morality to the client.
And Murphy said it out loud. His job, he told the Commission, was to explain the law and not to tell the Crown what it should or shouldn't do. That idea gave every one of these lawyers cover.
Researchers Richard Moorhead and Stephen Vaughan actually studied this exact pattern in corporate lawyers. They interviewed dozens of them and found most take client instructions at face value. They only step in when something's impossible to ignore. Crown's conduct stayed just under that line because it was always dressed up as a technical legal question.
But there's a limit. Importantly, even the standard conception does not authorise a lawyer to assist an unlawful objective. The Australian Solicitors' Conduct Rules require independent judgments and only lawful, proper and competent instructions. So professional doctrine was available as an enabler. It was simply interpreted in the least demanding way. And this is even confirmed with tribunals already rejecting this exact defense. In Fleming, a lawyer who said he was just following instructions was found to have become, in the tribunal's words, the moving force in the resulting misconception. The lesson is that instructions don't excuse a lawyer from using their own judgment.
And finally, weak accountability. The regulator's powers were limited, and the real chance of being caught was low. When there's almost no consequence, playing the odds starts to look rational.
So where were the enablers? Some existed, though what was missing were the structures that forced a pause, independent review, a rehearsed challenge to the client, and clear escalation when the client refused to change.
The good part is that this tells you the fix.
It's easy to finish a case like this with one sentence: the lawyers should have said no. And while that's true, it's partially incomplete. What we should be asking is how we turn the no from a career-defining act of rebellion to a supported and professional decision. Our recommendation is to work backwards from the mistake, what the lawyers need to know, value, and do, and what the organization and profession should build around them.
Thanks, Abraham. So let's rebuild it, and we'll fix it at the same 3 levels you just pulled apart: the lawyer, the firm, and the profession. First, what lawyers need to know. Rule 8.1 does not reduce a lawyer to someone who answers the narrow question asked. A lawyer must follow lawful, proper, and competent instructions and bring independent judgment to the problem. For a regulated client, independent judgment must include the regulatory purpose. Crown's license depended on ongoing honesty and integrity. The question was not only, can we argue this, but is this consistent with remaining suitable? Any issue involving a regulator, public revenue, or likely unlawful conduct should operate as an ethical trigger. At that point, the lawyer should slow the decision down and ask the Commission 3 questions. Is it right? Is it honest? And does it thwart the purpose of the law?
Second, what lawyers need to value. Wendell's fidelity to the law approach anchors loyalty in the client's genuine legal entitlements, not simply its commercial preference. The paramount duty to the administration of justice must be treated as a real source of motivation. For in-house lawyers, professional independence must remain visible, even when the employer signs the paycheck. Giving voice to values makes that practical. Lawyers can rehearse responses to predictable rationalizations like, "We have done it for years, everyone does it, and it's defensible." These objections become a practiced professional response rather than a sudden test of personality.
Third, what they needed to do. On CUP in 2012, the advice should have been clear. The process carried a real risk of breaching Section 68 of the Casino Control Act, and the Crown could not proceed merely because a defence might be available if detected. The advice should have been to cease the process. On casino tax, deductions that Crown's own advice described as not or probably not deductible should not have been claimed or concealed. When the regulator investigated, the lawyers should have disclosed that Crown's internal advice had questioned the deductions. During regulatory investigations, the lawyers should have produced documents, reviewed breach schedules properly, and refused strategies that frustrated the regulator. Foresight shows that advice can create liability where the lawyer knows the client's purpose is unlawful. Ryder Hall addresses incomplete disclosure, and Fleming confirms that client instructions do not excuse independent duty.
Individual action also needs organisational support. An independent ethics officer outside commercial hierarchy, mandatory escalation, documented high-risk decisions, and periodic independent review of standing advice. A recheck could have challenged CUP before the proposed Perth expansion. Training should also target ethical fading, loss framing, normalisation of deviance, and the mere technician mindset. Senior lawyers and general counsel must visibly model ethics first judgment, giving junior and mid-level lawyers real examples of respected practitioners declining unlawful instructions. At the professional level, continuing legal education should make clear that in-house and regulatory advice carries the same fidelity to the law as a courtroom work. The standard conception cannot be used as a license to assist conduct a lawyer has reason to believe is unlawful. There should also be a clear escalation norm when a regulated client persists, through senior escalation, independent advice, withdrawal, or referring the regulator where obligations permit or require it.
Finally, accountability must be credible. The supplied analysis argues that facilitation of likely unlawful conduct should be capable of engaging sections 296 and 297 of the Legal Profession Uniform Law and the fit and proper framework in Foreman. Foreman treats discipline as protective. It protects the public, maintains trust, and marks the seriousness of professional conduct.
So the fix is not simply find braver lawyers. It is better legal judgment, rehearsed ethical speech, independent review, clear escalation, and real accountability. Or, in the Commission's simpler language, ask whether it is right, honest, and consistent with the purpose of the law. Then, build a system that makes acting on the answer possible.
So what can we learn from this? Crown Casino wasn't brought down by one bad decision. It was years of experienced lawyers asking the wrong question. Not, is this right, but can we get away with it?
REST model shows a chain of failure. Warning signs were reduced to technical risks, judgment became probability, and commercial pressure displaced ethical motivation. And the lawyers did not follow through.
The chain kept repeating because rationalization made the advice field defensible. Additionally, Crown's culture prioritized revenue with repetition normalizing misconduct and weak review removing the handbrakes.
Our recommendations are not about creating lone heroes. They make independence routine through ethical triggers, independent review, and credible accountability.
Crown's license depended on public trust. The legal profession does too, including trust that lawyers do more than calculate whether a client will be caught.
A lawyer can explain the edge of the law.
But when a client is prepared to cross it, an explanation isn't enough.
The question is not only, can we argue this?
But it is, should we let this happen?
Because when legal advice becomes a map around the law,
The lawyer isn't just observing the problem.
they may have become part of it.